Hello everyone, it's Wayne Jones, the Course Coordinator for Australian Employment Law. This is week 5 and we're looking at Enterprise Agreements, Chapter 8 in your textbook, and these are my thoughts on some of the material that you're being asked to read this week. Okay, well first and foremost we'll be looking at this week's reading in 2 parts just because Chapter 8 is quite extensive. So the first part, let's have a think about the process for making an agreement and some of the rules that regulate making the agreement. What's the involvement of the Fair Work Commission in the regulatory process? The reading is Chapter 8, Enterprise Agreements. Why do you have a registered agreement? We've already been advised that you can enter into an agreement of any sort with an employer. And this includes just a standard contract between the two of you. We've been told that there's a safety net, and that safety net is either the National Employment Standards and other legislative instruments which deal with things like workplace health and safety and work cover, etc. Or there might even be an underlying modern award. So in the face of that, why would you have a registered agreement? Well, the reasons given by the textbook authors are that you would consider a registered agreement if you wanted to modify some of the award provisions that you were not happy with. For many organisations, and that would include organisations like the university, but other large institutions, management like to lock in the wage increases which are going to take place over the next few years. So if you have a look at the enterprise agreement that we have for this university, for example, you'll see one of the provisions sets out the wage increases over the life of the agreement. It also means that you have a workplace which is free from industrial action for a set period, and that usually takes you right through to the expiry of the existing agreement, because industrial action is otherwise prohibited during that time. And all of the instruments which make up the relationship between employer and employee come together pretty much in a single comprehensive document. Under the Fair Work Act, the making enterprise agreements are dealt with under Part 2.4. Section 171 sets out the object of creating enterprise agreements, and that object is in part extracted here, namely to provide a simple, flexible and fair framework that enables collective bargaining in good faith, particularly at the enterprise level, for enterprise agreements that deliver productivity benefits. So you'll see in there a reference to productivity benefit. That was one of the things that was expected by the government to be an outcome of introducing enterprise-based bargaining, and it needed to be done in good faith, and particularly it had to be simple, flexible and fair. So who's involved? Well, Section 172.6 says you must have more than one employee, and the short answer to why that's the case is because the Labor government was moving away from Australian workplace agreements. That was a single agreement, a single contract that an employee might be asked to sign by an employer. Section 12 in the Act gives a fairly broad interpretation to the word enterprise. So it says that an enterprise is any kind of business, activity, project, undertaking, a really broad definition. And in fact you'll see a comment at one point in the textbook along the lines that it also includes a new arm to an existing business. So you might have a business that's already involved in a project somewhere. It goes to it decides to move into a different field. That could be a new enterprise under Section 12 of the Act. Under Section 183 of the Act, a union that's been involved in the process of negotiating might provide a written notice saying that once the agreement has been concluded and it's now being put up for approval, it would like to be bound by that agreement as well. Is it a contract? Really an interesting point. There's an extract of a paragraph which I've taken out of the case that's mentioned in your textbook. That's Toyota and Marmara. And essentially what was happening there was it was an attempt really to reopen an agreement. And so what the court was looking at in that case was whether somebody who'd been a party could equally decide that they now wish to reopen the agreement. And so this interesting extract tells us that although the Act talks about people who are empowered to make enterprise agreements, usually the employer and the employees who are employed at the enterprise, you'd think of those as parties, and then parties perhaps to a contract. So a contract lawyer would assume that they'd be party to the agreement and that the assent of all of them would be necessary for the agreement to be made. But the lawyer would be wrong on both counts. The Fair Work Act does not identify the employer or any employee as a party to an enterprise agreement. So an interesting concept. It's an agreement. These parties come together to bargain. They put up a proposal, but it's the Fair Work Commission that provides the ink on the document, if you like, confirming that it is satisfactory as an industrial instrument. Anyway, interesting point. Section 3 rates a mention in your textbook as well. It refers to the early part of the Act, which sets out that individual workplace agreements, the so-called AWA, the Australian Workplace Agreements, have no part in the Fair Work system. So have a look at that section, because it's right at the very beginning, where under objects in Division 2, so the object of this Act is to provide a balanced framework for cooperative and productive workplace relations that promotes national economic prosperity and social inclusion for all Australians. And then it's got a number of points by which that's going to be achieved. But very interestingly, it's quite clear in that section that AWA's individual agreements are not going to be part of this new system. However, just a reminder, as your textbook authors remind you, that the Act still applies and still allows for flexibility terms. And remember, that's where both every award and every Australian workplace agreement needs to allow for some flexibility. So Section 202 says they have to be included. And remember also that we looked last week at high earning employees who were in a position to contract out. So there is still some scope, but certainly not under enterprise agreements. Usually there is reference throughout the text, well, here and there, to multi-enterprise agreements, but probably not enough is said about it to be too concerned. I'd ask you to be more concerned with single enterprise agreements, although be aware, and the examples that are given in the text are quite good, be aware that under Section 172.5, subsection 5 of the Fair Work Act, there's provision for groups of employers to get together to have a single enterprise agreement where there are two or more of them, but they're related in some way. And when you read the section in your textbook, it's paragraph 8.4. When you read the section, you'll see the common sense of it. It talks about the fact that they're related, so there might be a related company. They conduct a joint venture together, or they're working on some common enterprise. So, for example, think about maybe a construction site or a new mine, something like that, where there's a number of bodies, but they are related in that way. They have a common enterprise. So joint ventures, common enterprises, related bodies, and they have an authorisation in place. So they might have applied to Fair Work Commission to deal together for a single enterprise agreement. See specifically, and there were a couple of case examples that were given, I'll come to in a second, but see specifically Section 249.2, which talks about franchisees, and you're probably aware how they work. They're individual businesses. They usually have their own little company. So you might have a whole series of takeaway food stores under a big chain banner. Each of them is run by an individual company, but they're part of a franchise and they're regulated by contract. They are going to have a pretty common interest, and it doesn't make a lot of sense that they have all different types of pay rates. So they're dealt with specifically under Section 249(2). Have a look at applications for single interest authorisation. They get a mention. Look at 248(1), and the two examples that were given there, if you click on those links, they'll take you through to have a look at them. But essentially, it's pretty common sense. They have a common interest. The Lutheran schools, the Stewart Home School, they wanted to negotiate an agreement as a group. Which agreement applies? Well, you might have multiple agreements within an enterprise. That's entirely possible. So you might have an enterprise agreement which deals with some employees and another one that deals with different employees. If you have a look at the university, for example, it's got a couple of enterprise agreements on the go at the moment. But only one enterprise agreement can apply to each employee unless they do two jobs. So have a look also at Section 58(2) in the Act regarding the application of a new agreement before and after the old agreement expires. So essentially what happens is the old agreement will continue to apply until it naturally expires, or unless the new agreement deals with it in some way. So look at 58(2). Now, sometimes the initial dispute, before you get down to the body of the enterprise agreement itself, is going to be over the scope of the agreement. So who's going to be in the agreement within a single enterprise? So an employer can have different agreements at different locations, or even different agreements for different groups within the same location, but you can't really split them up arbitrarily. I guess that's the point of all of this. So when you're pulling together an agreement, the people, the employees who are included, need to be fairly chosen. And you'll see, if you have a look at some of the cases which rate a mention, you'll see that it's usually sort of bad behaviour that brings this to the fore. You've got an employee, for example, who's trying to rort the system. Sorry, an employer who's trying to rort the system by having a very small group do the voting and then bring in the balance of the employees after the event. But if you look specifically at the Melbourne Nursing Agency case, I think that's the next one. Yes, the examples that are given in the text are quite good. So in the CFMEU and Hamburger case, there was a clause in there that allowed employees just to opt in and opt out, and the Commission said, well, we can't really work out whether it's fairly chosen because we don't know who we're going to be dealing with at a particular time. We don't know whether the being allowed to switch around like that it enables us to guard against any unfairness. The Melbourne Nursing Agency case, again a link there on the screen, small group of permanents in an agency setting. So they were like the employees who worked in the office all the time, and they were effectively getting to vote over the terms and conditions for the much larger group of casuals in an agency setting, and they really weren't fairly chosen. Okay, there was a mention of a case in your textbook at the end of 8.5, the case of John Holland and the CFMEU. Now, what happened there was it was a I'll just jump back. I think what happened in this John Holland case, which was on appeal, and there's a shorthand version of it in your textbook, was there was quite a small group of workers who were going to approve an enterprise agreement for a larger group. Now the textbook says a much larger group, but it wasn't actually that much bigger. It was something like, I don't know, less than half a dozen initially voting, but the total number who were going to turn up and be employed by John Holland eventually were only about 25. So I don't know that I agree with the comment that it was a much larger group. And nevertheless, if you have a look at the case, there was some concern that I don't know, there was something unfair about it, that the employees who were ultimately going to be covered might not necessarily have agreed with it. There might have been some unfairness in the dealing, but there's just to make it easier for you, I've given you a link there to an article written by Cause solicitors with a bit more detail. Essentially, the agreement was allowed to stand. The court said it was not really just always about the numbers, although it was fair that it was going to give rise to some suspicion. It was more about was the decision being made by the right staff, and in the circumstances I described, where there were only a handful voting at this stage, but the ultimate workforce was only going to be about 25. The court found that it wasn't really a manipulation, and it wasn't an attempt to defeat the purpose of the Act. So, look, have a look at that, because it obviously caused a bit of a stir, having had a mention in the textbook. Next, let's have a talk about Greenfield Agreements. In your textbook refers to Greenfield Agreements. Have a look at Chapter 8.7. Have a look at Section 172.2, which talks about the definition of what a Greenfield Agreement is. Now, I'll jump ahead for a second. The reason that they're attractive is that there's no voting. They're put together in advance only by the employer and the union that's going to have the coverage at the site, and then they're put forward to the Fair Work Commission to approve. So that, for example, if a company was organising financing, getting a business, a new enterprise up and ready to go, they could have their they can do their budgeting, because they will have their employment arrangements in place. So because it's only, there's not much oversight, only signed by an employer and a union before it's sent off for approval, have a look at what needs to be satisfied. Under Section 172, it really has to be a new enterprise. It can't be an old one rebadged, and it certainly can't be a business which is simply being sold to another business. The employer has to have not started to employ yet, so no one's employed at this stage. It has to be negotiated with a union that's likely to represent a majority of the employees. That's 187.5a. And when the Fair Work Commission looks at it, it has to decide that, okay, well, it's probably in the public interest to approve that Greenfield Agreement. All right, well, let's talk about making an agreement now, and what are the required steps. Bargaining starts with a written notice to employees advising them of their representational rights. Now, if I take a step back, what happens first of all is the boss has decided, the employer has decided that they're keen to have an agreement. They're ready to bargain. On the other hand, I'll talk about this more in a second, if they don't, if they haven't voluntarily said they want to start to bargain, there might have been an order made, particularly around representation, or there might have been some other order made. So, for example, just bear with me, there could be a scope order made, or a majority support determination. But I'll talk about that in a second. But the point is that it starts off with a written notice to employees saying you've got rights to be represented at the bargaining, at the discussion. Those notices should go out no more than 14 days after the employer agrees to bargain, or there's a scope order or a majority support order made. And you can't vote on that proposal until 3 weeks, 21 days after that last notice has been given. So everybody's got their notice, everybody gets 3 weeks to think about it, and then you can have a vote. 7 days before the vote at least, everybody has to have a look at the agreement, and it has to be explained in an appropriate manner. Now look at section 180, and you'll see that appropriate manner talks about taking into account who's in the workforce. So if you have a workforce that's made up of lots of people who with whom English is a second language, for example, you may need to have interpreters available, but in an appropriate manner. So a copy of the agreement has to be available. It can be made available online. That's not unusual to make it available on a website and let everybody know where it is. Usually too, just I think to be on the safe side, the employer will say, and you can always pick up a copy at the office. Section 181, you submit the draft to a vote 21 days after that last notice has gone out. That's the notice to the employees that they can seek representation. Now this is interesting. Section 182, it's not a majority of the workforce, it's a majority of those who cast a valid vote. So those who choose to vote, if they decide to cast a vote, it's a majority of those who cast a valid vote. And as I mentioned to you earlier, if it looks like the agreement's going to get up under Section 183 of the Fair Work Act, the union can then notify Fair Work Commission that it wants to be a party. The Fair Work Commission will then have a look at the proposed agreement and just look at sections 186 and 187 in the Act, and they'll tell you what the Fair Work Commission is looking for. Essentially, they'll want to make sure that the group that's done the voting has been fairly chosen. So think back to that group that I mentioned before, where the very small group of permanents was going to vote over the top of a very large group of casuals. That there aren't any unlawful terms, that the agreement has at least got a nominal expiry date. Now that's anything up to 4 years. Has a disputes clause. Its terms aren't inconsistent with the national employment standards. So look at 186, 187 for the full list of things that the Commission is looking for under its general requirements. And Section 54.1 tells us that after Fair Work Commission approves the draft as an enterprise agreement, it will come into force 7 days later. I'm guessing, although nothing was said in the text, I'm guessing that that's to allow a reasonable period for an appeal. Are there any other considerations? Well, your text refers to these, and I think they're all points well made. What needs to happen during this whole process is that the employer needs to take reasonable steps to do the things that were mentioned before. So to get a copy to people, to let them know what the force and effect of the agreement is going to be, to provide explanation, etc. Reasonable steps. Good or fair? Like with any contract, there is really no obligation on the parties to make a good or fair bargain. It's just that they are properly represented, they get a chance to consider everything that's in the agreement, and that generally speaking it doesn't infringe the national employment standards, it doesn't infringe on the safety net, but whether it's a good or a fair bargain is not really the business of the Fair Work Commission. It comes back to that old thing with contracts that parties are free to make a bad bargain if they wish. We'll talk a bit more about good faith bargaining later on, but if there's a scope order in place under Section 187, that may not apply. The application is decided by Fair Work Commission generally on the papers, and note the comments in your textbook that various parties are open to challenge the agreement. Now, there's nothing said about how quickly that needs to happen, but various parties may challenge the agreement, and that includes the Minister. An agreement must demonstrate that the employee will be better off overall. And you'll see in the textbook, the reference to how this test was developed started really on the basis that, start from the basis that it was possible to, under the no disadvantage test, to swap one thing for another. So it was more a global or an on-balance test, so that it was possible for an agreement to remove an award entitlement and then give the person something else in return, usually higher wages. This test is, and then that test was got away with, so it was eventually possible to remove award entitlements without giving anything back. Now we've moved to the better off overall test. So better off overall than they would be under the award. And the way to do that is to identify specific terms that are better and specific terms that are worse. And the best example of an agreement being knocked out is probably that Bupa Care Services case that gets a mention at 8.11 in the textbook. Think about this. What they were agreeing to do was they said, we'll always want you to do some overtime, and we'll pay the rates for that. But under this agreement, you can also volunteer to do additional hours, but we'll just pay you the flat rate for those. So if you wanted to volunteer to do additional hours at the ordinary rate, you could do it. And it's said, at least, that the employees were quite okay with that. It gave them an opportunity to earn some extra money if they wished. It was entirely at their election, but they wouldn't get the above award rate for doing overtime. And it was knocked back by the Fair Work Commission, which said, well, really, that's just not going to have the employees better off overall, even if that's their opinion. And that's because penalty rates could simply disappear in this enterprise if there were enough people who were just willing to put their hand up to do extra hours at the ordinary rate. Undertakings, worth a mention. Imagine you get almost to the end of the process, you've bargained hard, you've got an agreement which you think is satisfactory to all of the parties. It's been signed off and sent up for approval, and the Fair Work Commission finds something in it that they don't particularly like, they question, they might even suggest that it's not appropriate content. Rather than start the process all over again, a letter can be attached to the end of the agreement, and what it might say is something to the effect that the employer agrees not to use or to enforce clause X, Y, Z, whatever the offending section is in the agreement, and that then forms part of the agreement as approved. So it's an undertaking saying, all right, for the purpose of keeping this thing moving along, we'll agree that we won't use that particular clause. Have a look at the agreement that I have provided on the Moodle site, and you'll see an example of such an undertaking. Who can bargain? Who are the bargaining representatives? This has a mention at 8.14 in your text. Look at section 176 in the Act. The employer, naturally enough, is a bargaining agent for the purpose of pulling together an enterprise agreement. They are their own bargaining representative. And then, just to shorten things, the employer or any employee who may authorise someone in writing to be their bargaining representative. Interestingly, the employee can't be their own bargaining representative unless they send in a notice in writing telling the employer that they intend to be their own bargaining representative. And of course the relevant union, and I use the word relevant because as your textbook points out, you can't have a union poaching into someone else's pool. They have to be the relevant union that would ordinarily have coverage at that enterprise. If you again look at the agreement which I've provided for you on the Moodle site, and you'll see the names of the unions who have members here at the university who represent members, and they are recognised as bargaining representatives for the purpose of the uni's enterprise agreement. Now, the textbook refers to protected industrial action. Good point to be made is, of course, that unprotected industrial action, certainly prior to the Fair Work legislation, was the subject of civil suits. So what was happening was you were seeing unions that were taking industrial action being sent broke because employer groups were suing them over things like secondary boycotts. Now, that can still occur, of course, but you couldn't have, for example, the transport workers locking up an enterprise. No trucks will be allowed in here, bringing the whole enterprise to a grinding halt. What was happening was that enterprise was then suing the union for damages through the civil courts. So protected action is legally sanctioned industrial action that gives the parties that are involved immunity from prosecution or further sanctions, so they won't get sued for damages. They're not allowed to be sacked. They're not allowed to be otherwise punished if they're involved in legally sanctioned industrial action. A lockout can happen when the employer shuts the gates in response to a strike or other action. A strike can happen if it's authorised in a ballot, approved by a majority of members, and then that's approved by the Fair Work Commission after there's been a genuine attempt to settle. Can't have one before the end of the enterprise agreement, so that harks back to what I was saying before. One of the reasons to have an enterprise agreement is so that you have an industrial period of industrial harmony. Can't be over unlawful or non-permitted material. So remember how we'll talk in a moment, talk in a little while about what can go into an enterprise agreement, but just hark back for a moment to awards and you'll get the picture. It's quite limited as to what can go in. So it has to be about if you like, a lawful dispute. And pattern bargaining. Pattern bargaining is where across a sector, and again I'll use the university sector as an example, across a whole sector, unions at individual workplaces, at individual enterprises, are all trying to line up a particular, say, a wage increase. So pattern bargaining might be nothing to do with this institution up here in central Queensland, but the NTEU, for example, might be just to make up some figures. They might have decided they'd like to get a 10% wage increase across the board for all universities. That's called pattern bargaining. That's not allowed. The enterprise, the whole idea of an enterprise agreement is it's a bargain that suits that particular enterprise and that particular group of employees. Can't use coercion when you're bargaining, and that's part of the general protections that are provided under Section 343 of the Fair Work Act, which says it prohibits a person from seeking to coerce another person as to the exercise of a workplace right. And that also means to exercise that right in a particular way. Section 341 in the Act defines a workplace right to include the process of making or approving an enterprise agreement. So, unprotected industrial action, lockouts, threats of dismissal, etc., they can't happen. But note some of the exceptions that are provided there at 8.16 in your textbook, particularly around things that were done by the government. So in the NTEU case that's mentioned, the federal government said, well, we're going to withhold funding if you don't tune up the provisions in your agreement a particular way, and I do recall that being the subject of a pretty vehement action. And have a look at the Commonwealth Bank case. I thought that was interesting too, where the union had a campaign to induce a bank's shareholders to put pressure on the bank to resolve its dispute with its workers, and that was said not to be coercion. It seems to have the have to have almost an illegal or some form of illegitimate effect before it becomes coercion. So there's plenty of room for good, robust pressure to be put on each of the parties without stepping over into coercion. You have to have a look at the cases, though, to get a better feel for that one. Misrepresentation, and that's really knowingly or recklessly making a false or misleading statement about a workplace right. So note there, knowing or recklessly. They're just making foolish representations about how good the new agreement is going to be and how much better off everyone is going to be. Of course, you can still have sort of mere puffery, silly statements, but if it crosses over and it starts to be knowingly or recklessly false or misleading, then the outcome may well be that the Fair Work Commission can be convinced that it's not really a genuine agreement, that people were induced to enter into an agreement based on something that was false. Bargaining in good faith. Quite an interesting provision, and I'd ask you to have a good close read of section 228 and note particularly the fact that there's nothing in that section that says that the parties need to give way. There's nothing that said that parties need to be extremely flexible, anything of that nature. The provision is quite detailed, and if you do have a look at it to section 228. I'm thinking of 228.2, just reading it out. It says, the good faith bargaining requirement doesn't require a bargaining representative to make concessions during bargaining for the agreement, or a bargaining representative to reach agreement on the terms that are to be included in the agreement. And one of the cases that gets a mention in your textbook deals specifically with that, where it was held in the Endeavour Coal case that it was a bridge too far to insist that the bargaining representatives explain, well, what are the provisions that you definitely will agree on. Anyway, have a look at the various cases there, but essentially what you do need to do is you do need to show up, you do need to actively participate, you do need to disclose information, but not necessarily confidential information. You should be responding to correspondence from the other side in a timely way, and you have to demonstrate that you've given general consideration. Now, you don't have to change your view one iota to be bargaining in good faith, as long as you're still doing those things. You're turning up, you're talking it through, you're disclosing information, you are providing timely responses, you are thinking about what's being proposed by the other side, but there's nothing that says you must make concessions. What will happen, though, if you are too intractable, is that one of the parties may apply for a bargaining order, and that might be something that you want to avoid. A bargaining order happens when the process is just not working. Particularly, a bargaining order might apply where the parties have written to each other, they've made it clear that that's going to be their next step, so there is warning given, and what can happen then is the Fair Work Commission can step in and say, there are too many people around the table, we want to reduce the numbers, or a representative who's been particularly difficult might be excluded and another representative has to be introduced. There might be directions given on process. The parties might be told to meet at specific times, exchange drafts, disclose information, etc. If you don't do it, then you will leave us. It is open for the person or the employer or the employee to suffer a penalty, or a serious breach declaration might be made under section 235. And if you look at section 235, what you'll see is what that leads to is an opportunity for Fair Work Commission to step in and arbitrate an outcome, which, as I said, most people don't necessarily want. What happens if the employer won't bargain? Look at sections 236 and 237 in the Act. This is the situation where a group of employees would very much like to have an enterprise agreement, but the employer just won't countenance the idea, won't talk about it. If the majority of the employees who will be covered want to bargain, the employer won't, the group is fairly chosen, and the order is reasonable in the circumstances, then under those sections of the Fair Work Act, Fair Work Commission may make an order called a majority support determination. Now remember what I said before, that's the point at which the issue of the notices telling employees that they can now appoint a bargaining agent, that's the trigger. So the employer now has to do something within the next 14 days. Similar to that of the scope orders we mentioned briefly previously, that's where any of the bargaining representatives can apply to the Fair Work Commission to say we can't really reach agreement on the scope of who's going to be in our enterprise agreement. We think all of the clerks should be in it, but we don't think the plumbers should be in it, something like that. An order that will promote the fair and efficient conduct of bargaining should be made. The group is going to be geographically, operationally or organisationally distinct, and in making these orders, Fair Work Commission should take into account the views of the employees if there's really not much to choose between the different views. So if it's possible, if it could go either way, the Fair Work Commission should consider the views of the employees. Look at the cases in that area. There's some quite interesting case examples given to you about making scope orders, and it is, or it can be, a contentious area. You'll see some good examples there of different considerations that the Commission's taken into account in deciding how to group the particular groups together to make an enterprise agreement which will promote fair and efficient conduct of bargaining. So if you've got the groups are just too disparate, then Fair Work Commission won't try to jam them together. And probably a good example there that you wouldn't have thought of would be that AMWU, Australian Metalworkers Union, against Shinagua Refractories, where they said there'd just been too much animosity between two unions representing separate groups. So anyway, interesting point, but the key in that 238 for me, I think, is not only is it a fair representative order that meets that requirement of having some sort of geographic, operational, organisation tie, but also that it promotes fair and efficient conduct of bargaining. But have a look at the cases. They are at 821 in your textbook. Now the Fair Work Commission can step in and try and resolve disputes. If I jump ahead again to where I was before, the sorts of things that most parties don't want is for the Fair Work Commission to actually step in and make its own order, arbitrate, come up with its own determination, a workplace determination, which I'll mention in a second. So these are steps along the way. Section 240 says that a bargaining representative can make an application to Fair Work Commission to step in and deal with a dispute. They just can't settle it. It tells you what needs to happen. See also that in 244, the Commission can be asked to arbitrate if that's what everybody wants. If everybody puts their hand up and says, we're not going to get to the end of this, we'll be happy to have you arbitrate. And of course, the Commission may arbitrate just a part of the dispute that's part of the problem, with the rest of the agreement falling in behind. Look at those sections that I've mentioned, 418 to 420, about restraining various actions, stopping people from taking unprotected action. 423 to 426, protected action can be suspended in certain cases. And look also at Section 595, just a reminder that at any stage the Fair Work Commission can compulsorily require parties to come to arbitration and mediation. And that's really in any sort of dispute. We'll talk about that section again in the future. Now, at the end of the road, where we've worked out who's involved, we've worked out who the parties are going to be, and the enterprise agreement process, the bargaining has been proceeding, but just like parties can't get to the end of the road. This is what can happen. If industrial action is stopped under any of those sections that I've mentioned there, 423, 424, 431, or one of the parties just is not bargaining and a serious breach declaration's been made, so they've been ordered to do something, they've been ordered more than once, they're just refusing to do it. Under section 235, a serious breach declaration is made, which says that it virtually says one of the parties is just intractable, will not cooperate. What can happen then is that the Fair Work Commission can proceed to make its own determination. Section 279 says that what comes out the other end will have the same effect as an enterprise agreement, but it's essentially an agreement which has been made by Fair Work. Well, that's the first half of Chapter 8, and I wanted to move on in a moment and talk about content, variation and effect. But just before I leave that, can I make a point to you, just reminding you that for our current purposes, which is really an introduction to this topic of employment law, there is a reference, there's been reference throughout the chapter so far to multi-enterprise bargaining, multi-enterprise agreements, and then there's a reference to multi-enterprise bargaining in low-paid sectors. Look, let that go by. Have a look at it, have a read of it, and for your interest. But I would like you to concentrate principally on workplace agreements for pretty much for a single enterprise, except for the case where I talked about earlier with the multi-enterprise agreements, where there was a commonality between the businesses, and that was the Lutheran Schools case, the Stewart Home case. So where you've got related corporations, joint ventures, etc. But don't be too concerned about multi-enterprise agreements for our current purposes. All right. Well, in a minute I'll continue the discussion around content of agreements, their variation, and the effects of agreements.